Most people think of trial as being the focal point of all litigation. But more argument and drama happen in discovery, as I've said previously, than it does in the courtroom. So today we're going to continue our series on the tools of discovery. And today, the discovery tool that we'll be talking about is the request for admission. Here's what we're talking about today. A request for admission is a tool that is used to reframe answers from interrogatories, or from requests for production, or from documents that have been obtained, or other facts that develop in the course of litigation into the frame of the other party admitting something as a fact. Now, lawyers are always skittish about admitting anything as a fact, and sometimes they'll go to ridiculous lengths in order to avoid admitting a fact, and you'll see that in some of the things we're going to do today. What follows are requests for admission that were served on the defendant in a contract action. The plaintiff in that case was suing our defendant for refusing to pay for his architectural services. The major problem with his claim was that he did not render all of the architectural services which he promised to render and on which his claim was built. While our client was not completely blameless in all of this, having made multiple changes to the original design, he nevertheless had a point that the plaintiff had failed to fulfill the letter of the contract. We decided that we would file a counterclaim under Missouri's Merchandising Practices Act. Under that statute, you could claim at that time what amounted to fraud without having to meet all of the standards for a fraud claim. Services, in this case the architectural services, were services that fell under the Merchandising Practices Act in Missouri as long as they were provided to a non-commercial or homeowner. We wanted to assert that portions of the contract were deliberately written in such a way as to mislead our client. Under the law at the time, all we had to do was show that the contract had the capacity to mislead our client, and he would be able to defeat the claim of the defendant by bringing a counterclaim of his own. Let's look at the requests for admission here. The first request for admission said, plaintiff transmitted a proposal, Plaintiff's Exhibit 1, or A, that contained the statement, this proposal contains a binding arbitration provision which may be enforced by the parties, to the defendant. And that's what he did. He meant that when they contracted, he put that together, and that was the basis for their future dealing. The next assertion was, the number 2 request for admission was, plaintiff asserted to the trial court and the Southern District Court of Appeals that the proposal did not contain binding arbitration agreement. And indeed, that's what he did. He told the courts that the language didn't support a binding arbitration agreement, no matter what that precatory language said. Well, the problem for him was that he was both right and wrong, in that he was right that there really wasn't a binding arbitration agreement inside the document. But by having the statement up front that said that there was, and then having refused to allow arbitration, he was essentially weaseling out of a key provision of the contract. And our position on that was that that was deceptive. It had the capacity to deceive our client, and so he ought to be liable under the Merchandising Practices Act. The next one is the trial court found the document did not contain a binding arbitration agreement. And indeed, that was true. The trial court did find that, and it issued an order to that effect. Going on down a little ways, Phase 1 was for schematic design, and that's indeed what was said inside the contract. Phase 1 required TXR, the company, to prepare presentation exhibits and 2 full-color artist renderings. So, just looking at those, within 30 days, the plaintiff had to answer these requests. And here is what they said. First, they admitted, as they had to, that the contract that they had put into evidence with the court by attaching it to their complaint stated that it had a binding arbitration provision. And like I said, our theory was they put this in so they could force arbitration if they wanted it and could avoid arbitration if they didn't want it. Classic double dealing. Also classic for when someone drafts their own contracts without any real appreciation for what words actually mean. Then they got cutesy wootsy and came back with this on the next one. Objection. This request does not assert a fact as contemplated by Rule 5901, and therefore no response is required. Now, that right there is the statement of a legal conclusion, first of all, and second of all, this is an improper objection. You don't get to decide as the defendant or the plaintiff what's a proper fact under Rule 5901. And there isn't any case law that really deals with this issue. If it's a fact, if it could be proved in a court of law, then it is subject to being a Rule 5901 request for an admission fact. And therefore, the idea that no response was required was clearly out of bounds. Then they said, subject to this objection, plaintiff denies the assertions, factual or otherwise, in this request. Well, as I mentioned, first, it's an improper objection. Clearly, if they represented to the trial court that there was no arbitration agreement, and they did so in a pleading, well, then denying that in this manner makes it a bad faith failure to do discovery. I kept this in my ammunition for settlement time. I kept my powder dry. I didn't go try and compel them to answer this particular request for admission because at settlement time there was going to be no way for them to wiggle out of this. I would simply move to have the objection overruled, and the denial would then be what they made in this particular case. Well, if you deny a request for admission and the party who asked for that request for admission subsequently proves it up, they usually can get attorney's fees because the attorney on the other side wasn't playing fairly. So I didn't think they had any way to wiggle out of it. Then look at this next one. They said the same thing here. The trial court's order denying arbitration specifically said there was no arbitration agreement. So denying this simply would have meant that we got legal fees for proving it up at trial. Now, the lawyer was a young associate fresh from one of Missouri's lesser law schools, and he had very little experience in civil litigation, having mostly defended traffic tickets and misdemeanor criminal cases. This was the first case that the partners in the firm had actually given to him to run with. So I chalk it up to his inexperience here in terms of doing these objections, because the objections meant absolutely nothing. In question 7, in answering, they said this: objection, vague, and calls for a legal conclusion. Well, it is neither vague nor does it call for a legal conclusion. Then they said, subject to said objection, plaintiff admits that plaintiff's Exhibit A to its petition contains a heading which reads, Phase 1 Schematic Design Scope of Services. Plaintiff denies all the other assertions, factual or otherwise, in this request. Well, he's already admitted the heart of the admission. And so this whole nonsense with the objection and the denial of other assertions, which is ridiculous, doesn't do him any good. So you see what they did there. They admitted the fact, they just didn't want to make it a clean admission. At trial, we'd have moved to strike the objection and the jury would have received that evidence. Same thing with number 8. Well, this is how requests for admissions go in most cases. A good request for admission follows this rule: 1 fact per request for admission. You do several facts in a series, and then the chain of facts, 1 through 5, leads to a single conclusion. You leave the conclusion out because you can't get them to admit a legal conclusion. What you can get them to admit is all of the facts leading up to that legal conclusion. Well, that's all you need to do to force them into a situation where they're looking at summary judgment. And that's where we were headed on their claim. And we were headed toward getting summary judgment on our claim for fraud in the contracting part of the relationship. In that case, because there were admissions and because the defendant failed to respond to a summary judgment motion within the 30 days permitted by rule, we had them over a barrel. They claimed we owed $50,000. We claimed they defrauded our client. An innovative defense lawyer who was defending the architect on the merchandising practices claim, in other words, not the lawyers who brought the initial suit against my client, realized they had a huge issue with this Merchandising Practices Act claim and that it was probably pretty likely that our guy was going to, without a doubt, get a judgment against them. So they got their insurer, the insurer put them in to defend this. They had the insurer pay $45,000. And then that was for the merchandising practices claim, which came to us. We endorsed it back over to their client, and my client paid $5,000 because he thought the guy deserved something for having done a few drawings and some work initially. He just didn't think he deserved the whole $50,000. Well, the guy got the whole $50,000, but it didn't come from us. It came from his own insurance company. We paid him an extra $5, basically to get him out of our hair. The results for the admission weighed heavily in the result on that case. And so that's how we used it in one situation. Oddly enough, it was getting the case specially set with a different judge, one who did not hate me the way the sitting judge in that county did, that allowed us to work it out. You see, I made a huge mistake in that case. I annoyed the judge. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better, that would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.